How important is the PSR at sentencing? How much weight does the judge give to the PSR or the pre-sentence report? This is a question that comes up often in my practice. I'm Diane Bass, federal criminal defense attorney in Orange County, California. The pre-sentence report is prepared by the probation office, which is an independent entity. They do not work for the prosecution or the defense. They work for the court. They prepare a report and present it to the judge, which ends up being the first thing that the judge sees about a defendant or a person charged with a federal case before their sentencing hearing. The pre-sentence report is disclosed to the parties 30 days before sentencing. The parties, the defendant or myself on behalf of my client, and then the U.S. Attorney's Office filed their sentencing papers 2 weeks before the sentencing hearing. So I would imagine that most judges read everything all at once, but the first thing they are going to read is the pre-sentence report because it's going to give the judge an overview of the case. It's going to set forth the sentencing guidelines, any relevant enhancements, the criminal history of the defendant, and any personal factors, education, health, family upbringing, potential statement of acceptance of responsibility, and anything else that the probation officer deems important for the court to know about the case and the defendant prior to sentencing. The probation officer who prepares the report will also prepare what's called a recommendation letter. The recommendation letter is exactly what it sounds like. It is where the probation officer recommends a sentence to the court based on what the probation officer knows about the case and the defendant. Now, the probation officer has an opportunity to meet with the defendant for an hour or two during the pre-sentence interview, also known as the PSI. However, I, as your attorney, have known you probably at least many months, if not years, prior to the sentencing hearing. So you and I, as the client and your attorney, are in the best position to give the probation officer as much information as we possibly can about you and why you engaged in the offense and how remorseful you are for the conduct prior to sentencing. So we will provide all of this information to the probation officer even before we go in for the pre-sentence interview, so that essentially the probation officer is working off of our script rather than the government script, rather than just the discovery that they've read about the case. They are going to get to know you as a person, what's important to you, how badly you feel about your conduct, about your family, your upbringing, anything tragic that may have occurred in your life, and all of the wonderful things that you've accomplished and done, ways you've given back, how many people rely on you and love you. So these are all of the things that we want to be in the pre-sentence report, because again, it is the first thing that the judge sees about you prior to sentencing. But the question is, how important is it? It's important on many levels. First of all, many judges are what we call guidelines judges. So they stick to the federal sentencing guidelines. Now, it's been quite a while since the guidelines have been advisory instead of mandatory, meaning that the judge can vary from the guidelines. So most judges will vary a little bit here and there if they have grounds to. I've also seen judges vary upward, which is also a terrifying prospect. So what we want to do is provide the judge with as much information so that they will vary downwards if at all possible. So the question again is, how important or impactful to the judge is the pre-sentence report? Is the judge going to follow the pre-sentence report? And the answer to that question really is, it depends on the judge. There are some judges who do not care what the defense has to say, and they are just going to go by either what the government recommends or what the probation officer says in their report or recommends in their report, or perhaps a combination of the two if there's cooperation. Sometimes it's even tricky to get the judge to apply the downward variance recommended in the probation report and the cooperation motion that the government has made, making it a lesser sentence. So that is part of my job as your attorney, is to get the judge to include both things in their ultimate decision about sentencing. The hope is that the probation report, just like the federal sentencing guidelines, is just a starting point. And then I get to argue every single thing about you and your case, all of the things that I've previously mentioned, your history, your background, which is under the statute that we rely on most as criminal defense attorneys, the nature and circumstances of the offense, and the history and characteristics of the defendant. And this is where we spend most of our time arguing and telling the judge that these are the reasons why the judge should ignore what the probation officer says and do something different. Now, will the judge impose the enhancements that are set out in this pre-sentence report? Probably, if they are by the letter of the law applicable, then the judge is going to apply them. So I'm not going to tell my judge or the judge in the case that a certain enhancement doesn't apply when in fact it does. For instance, if there are more than 10 victims, I'm not going to tell the judge, well, you can't apply that because there weren't more than 10 victims. Well, there were more than 10 victims. Or I'm not going to say these weren't vulnerable victims if they were vulnerable victims. What I am going to say is, yes, there were more than 10 victims, there were vulnerable victims, but my client has made restitution. My client has changed his life. My client has made a plan for how he's going to make restitution. My client has learned he is a different person. So it is a starting point for the court. It is very important. It is the first thing that the judge looks at. But with a great federal criminal defense attorney, you can come back and argue that the recommendation of the probation office is too high, even if it's a favorable recommendation. Even if you have a probation officer who's recommending, say, a 5-level downward variance, go in and recommend or request a 7-level downward variance. Go in and recommend probation or home confinement. So again, it's a starting point. It's very important, but it's not the end all and be all. So once we get the report, that's when our work begins. If you found this useful or helpful, please subscribe to my channel and like this video. And thank you so much for watching. My name is Diane Bass, federal criminal defense attorney in Orange County, California.